It really depends on the nature of rehabilitation plan that the receiver will submit to the court for approval. Now, rehabilitation of a premium company may either be at the instance of several parties. It may be at the instance of the premium company, in which case it is filed with the regional trial court. It may be at the instance of the SEC, in which case the SEC may itself take over the operation of the company and place it under rehabilitation in accordance with such terms and conditions as the SEC may adopt and apply to the company. Or it may even be at the instance of the plan holders, although I have yet to see a petition for rehabilitation of the company done at the instance of the plan holders. In our cases, Your Honor, I think all of us receivers in this represented in this hearing were appointed by the courts because the plan holder, the premium company was the petitioner for rehabilitation, and its petition is filed in the regular courts. Now, as receiver of fair plans, I submitted a rehabilitation plan under which the interests of all the plan holders were valued, and under which their participation in the remaining, in the trust fund, in the outstanding trust fund, was distributed among them.
So in other words, a credit company may be placed under rehabilitation at the instance of the SEC, one, or it could be at the instance of the plan holders, two, or at the instance of the credit companies. May I know, in the cases of the credit companies that we are now investigating, what instance are they being under rehabilitation? Like, for instance, Pacific is that?
Pacific and CAP are under rehab based on the petition of the corporations.
And therefore, it is governed by the order of the court pursuant to the agreement of the parties.
You're right.
When we say agreement of the parties, do we mean both the plan holders and the credit companies should agree on the terms and conditions of the rehabilitation?
Your Honor, the printing company submitted the petition for rehab, and after informing all stakeholders and getting their views on the petition for rehab, the regional trial court finally gives the approval for a rehabilitation plan.
So it's at the regional trial court, is the proper court.
Yes, Your Honor.
Mr. Chairman, may I be given opportunity to add to what my colleague has stated? The rehabilitation plan is not a matter of agreement between the petitioning corporation and its plan holders and creditors. It is a plan prepared by the company with the aid of the rehabilitation receiver, which maps out the best possible way the premium company may be allowed to go back to its feet and regain its financial health. It may even be over the objections of the policy plan holders or against the objections of the creditors of the premium company. At the end of the day, it is the court which will decide whether or not a petitioning company will be placed under rehabilitation.
In other words, the court will decide on the basis of the petition, but the court has the discretion and the prerogative to impose such other conditions as it may be proper.
Yes, Your Honor, and whether or not a rehabilitation plan will be approved does not require the conformity of the creditors and the plan holders. They may even object vehemently against the approval of the rehabilitation plan but the judge may disregard all those objections if those objections are not reasonable under the circumstances.
When a printing company applies for rehabilitation before the court files a petition and applies for rehabilitation, what role is being played by the SEC?
Well, under PD 902-A, since a private company is under the jurisdiction of the SEC, PD 902-A requires the interim rules, I understand, require the consent by the SEC for the rehabilitation proceeding to push through.
I thought it's the court that has the final say on the rehabilitation. So if the SEC objects, then the court will have to listen to the SEC, to the SEC. Is that correct?
Mr. Chairman,
Yes.
in the case of TPG, the Phoenix company likewise initiated the petition for rehabilitation, and so this was filed with the commercial court, and the court gave due course to the petition.
Regional court.
Regional court, Your Honor. Because there are special courts assigned to the Supreme Court to hear rehabilitation cases. Now, I agree that it's not a matter of agreement between the Phoenix company and the plant holders, and even the SEC for that matter, because the court has full authority to approve or disapprove the rehabilitation plan being proposed by the Phoenix company. In the case of TPG, the SEC was represented in the proceedings as required by the interim rules. And a lot of other plant holders were also there representing their own interests. And at the end of the day, the court approved a rehabilitation plan that it deemed appropriate for the specific Phoenix company and for the specific circumstances surrounding the Phoenix company. I might add that in the case of TPG, the rehabilitation plan simply was a form of restructuring of the plan holder benefits to allow the trust fund to grow and for the trust fund to be able to meet the utilities in the time comes.
Congressman Golez.
Thank you, Mr. Chairman.
Mr. Chairman,